The case for today is Bandhua Mukti Morcha versus Union of India and others, AIR 1984. Bandhua Mukti Morcha, a non-governmental organization, they sent a letter to the Supreme Court of India about the bonded labourers working in 2 stone quarries in Faridabad district of Haryana under inhuman and intolerable conditions, contrary to various social welfare laws. They prayed that a writ be issued to release the bonded labourers. The majority of them were bonded labourers who had not authorized this type of work, resulting in unacceptable working conditions. Furthermore, the petitioner included the thumbprints of the bonded labourers in the letter. After realizing that the case had some merits, the Supreme Court of India viewed it as a writ petition under Article 32 of the Constitution of India. The Supreme Court alerted the relevant stone quarries and appointed an inquiry commission. Every person listed in the letter was spoken to by the commissioners at the quarries to inquire about their working conditions and whether they were doing it voluntarily or not. The commission submitted the report which supported the accusations in the letter. Coming to the issues. 1. The validity of the writ petition filed in accordance with Article 32 of the Constitution of India. 2. Whether the workers' fundamental rights were genuinely infringed or not. 3. Whether Article 32 of the Constitution of India gives the Supreme Court the authority to form any commissions or investigative bodies or not. 4. Whether the labourers referenced in the case are bonded labourers or not. 5. Whether the workers in this case are entitled to relief under different social labour laws or not. The petitioner's arguments. The alleged stone quarries had a lot of residues, making it difficult for anyone to breathe. Certain workers were working under strict orders and were prevented from leaving the area. The workers were compelled to drink dirty water from a nala because there was no option to provide them with clean water. The workers had to live in juggies that were too low to stand and were unable to find a safe place to live. Some workers had chronic illnesses, and workers injured in accidents while doing their job were not compensated, and no clinics were available for medical care. Contentions raised by the respondent. The Haryana state government argued that it was forced labour, not bonded labour, was used in the workforce. The state government of Haryana contended that the writ petition submitted by letter under Article 32 of the Constitution of India is not maintainable because the fundamental rights of the petitioner or of labourers were not infringed. The Haryana government argued that the Supreme Court did not have the power to appoint an inquiry commission, and report made by such commission had no evidentiary value as it was based only on ex parte statements which had not been tested by cross-examination. Decision. The Supreme Court of India first looked into the question of locus standi. Locus standi mandated that only those whose fundamental rights were violated could approach the court. The Supreme Court of India enunciated that if poor, disabled, or socially or economically disadvantaged person or group of persons to whom the legal injury is caused because of a violation of the fundamental right is unable to approach the court for judicial scrutiny, then any other person with a bona fide intention can file a complaint with the court on behalf of the former under Article 32, where they can approach the Supreme Court of India, or Article 226, where they can approach the High Court. The Supreme Court of India stated that it is an obligation for the government to investigate the matter of deprived and vulnerable sections of the society. Instead of complaining, they should tackle the issue as a challenge and guarantee that no one is denied of their basic human rights. The Honorable Court stated that in a country like India, where there is so much poverty, ignorance, and exploitation, any insistence on a rigid formula of a proceeding would become self-defeating because it would place enforcement of fundamental rights beyond the reach of common man. It is therefore not at all necessary that an adversarial procedure where each party produces his own evidence tested by cross-examination by other side. A strict adherence to adversarial procedure may lead to injustice, particularly when both the parties are not evenly balanced in socio-economic front. Therefore, the court had to appoint commissions to examine the matter. If the issue of bonded labor is brought up in court, the court will presume that the worker is forced to do so due to economic factors such as debt or advances. This presumption has the potential to be rejected if the employer or the appropriate government can prove in court that the worker is not a bonded labor. The Supreme Court of India directed that the government of Haryana to constitute a vigilance committee in each division of district to ensure compliance under Section 13 of the Bonded Labour Act 1976 within 6 weeks of the judgment, and the government of Haryana would appoint a district magistrate to identify the practice of bonded labour. It is necessary for the state government to seek assistance from NGOs and other voluntary agencies to ensure the implementation of the Bonded Labour Act 1976. The Supreme Court of India ordered the government of Haryana to rehabilitate the bonded labourers within 3 months of the judgment, and the Minimum Wages Act of 1948 must be implemented by both the central as well as state governments. Thank you.